So welcome everyone to the committee. Those participating in today's informational hearing, the hearing will be on the intersection between child welfare and domestic violence. And I also would like to thank my staff who has worked really hard to put this together, the panelists who are joining us here today from different parts of California, and all those who are able to join us remotely. I also want to thank my colleagues, Senator Skinner, and we're waiting for a few others that may join us later today for making the trip here today. We will be hearing from expert panelists working directly in the child welfare system or with victims of domestic violence who will discuss how these two intersect. In the first panel, we will hear from experts who will be discussing the legal framework of the child welfare system within the context of dependency court, identify some of the gaps currently visible when domestic violence has been identified. And the second panel will focus on what is possible and ways we can improve outcomes for children, victims, and families experiencing domestic violence. We will wrap up this hearing with a presentation from UCLA Pritzker Center for Strengthening Children and Family. We're going to be going over a recent report and its findings. I would like to now open up the dais for opening remarks from my colleague, Senator Skinner. If you have any opening remarks, you may do so now.
Thank you very much, Chair Rubio, and I'm really appreciative of your organizing this today because these issues are very important, and unfortunately, I think all of us have monitored the fact that during the pandemic, incidents of domestic violence were on the rise, and obviously this whole experience of having our lives so disrupted with shutdowns and not going to school or work has put pressure on everyone. And so for children who already are under the pressure and then maybe in a household where there is domestic violence, the consequences are great. And yet we also know that not often or not the norm, but our child welfare system in trying to address the needs of the children can sometimes not have placements that really do the best for them. And so we want to really make sure that we are addressing domestic violence, addressing child welfare, and doing the best for all parties concerned. So I really appreciate your setting this up. Thank you.
Thank you so much, Senator Skinner. As she stated, it's really important that we focus on the whole picture. I know I've been a strong advocate as well as Senator Skinner on domestic violence and pushing policies and children as well, but now we want to see how we can strengthen policies to help those caught in limbo, and children have to be in the center of this conversation. So I really appreciate the panelists that are going to bring us information, but also some recommendations, so I look forward to that. Before we begin with our first speaker, I would like to invite the public wanting to participate to call in now. Please dial the toll-free number, 844-291-5489, and enter the access code 2355343 to be added to the waiting list at this time. Now let's go to our first presenter, which I'm excited to hear from, Anya Emerson with the Family Violence Appellate Project, an organization which is dedicated to helping domestic violence survivors and their children appeal dangerous trial court decisions on their behalf for free. We will now move to our first presenter, Ms. Emerson. The floor is yours.
Thank you very much, Senators Rubio and Senator Skinner. It's an honor to be here and to be presenting to the committee on this very, very important topic. My name is Anya Emerson. I'm an attorney admitted in both California and New York. I currently have my own solo law practice after years specializing in family law and dependency in both states. However, I'm here today testifying in my capacity as a member of the Dependency Advisory Panel of the Family Violence Appellate Project. And I wanted to address three things in my testimony today. The first is that I've been asked by committee staff to give a very brief overview of what is domestic violence, because it's a little more complicated than, unfortunately, than many people think. The second is I'll explain what my organization does, the Family Violence Appellate Project. And third, I'll address some real issues that we see in the current dependency system in child welfare. So to begin, I don't think anyone at this hearing needs to be told that domestic violence is not a huge problem. 1 in 4 women will experience domestic violence in their lifetimes, 1 in 7 men, and more than 3 women every day in the United States are murdered by their intimate partners. Domestic violence also has very serious, severe effects on children, which I will not go into, but I think one of the later panelists will. But what is domestic violence? It's more complicated than violence. Many people think of it as a woman with a black eye, but it's more than that. It's a system of power and control. But domestic violence can occur in any relationship, no matter a person's gender, race, class, or type of relationship. Statistically, most abusers are men, and most victims or survivors are women, which means I will use the male pronoun for abuser and the female pronoun for survivor, but that is not, by no means, not always the case. At its heart, domestic violence is about power and control by the abuser over the victim. And this can take many forms. It can be physical violence. Strangulation is particularly dangerous because that's often an indicator of future lethality. Reckless driving and brandishing firearms are really very dangerous as well. Emotional abuse, calling a victim's derogatory names, telling a victim nothing she can do is ever right, the food she cooked is terrible, the house is a mess. Financial abuse, taking a paycheck away, prohibiting a victim from working or requiring a victim to work, ruining a victim's credit, taking out credit cards in her name, slashing her tires so she can't get to work, giving a victim an allowance or no money at all, requiring receipts for all purchases, threatening employment, taking away passwords to bank accounts. Those are all very common. Sexual abuse, rape, or requiring a victim to commit sexual acts she's not comfortable with, forcing a victim to send an abuser photographs or videos of a sexual nature and then using those later as blackmail or or publishing them. Abuse that uses religious authority figures or cultural precepts to either prevent a victim from leaving or to reinforce an abuser's authority. Gender role abuse, telling victims that good women do X or Y, or in LGBTQ relationships, threatening to reveal sexual orientation or preferred gender. Legal abuse, and this may come up later in this hearing, and abuse through governmental or authority systems. Abusers will often call the police on the victim. They'll call child protective services on the victim. They'll get a victim evicted from housing. They might try and get a victim deported by calling immigration. Medical abuse, including contraceptive abuse, requiring a victim to obtain permission to obtain medical care or preventing a victim from obtaining medical care, or sabotaging or forcing contraceptive use. Social isolation, cutting a victim off from family and friends, literally preventing a victim from leaving the house, taking away car keys, house keys, cell phones. And technological abuse, tracking a victim at all times, GPS tracker, cell phones, monitoring email communications, requiring she hand over all passwords. And finally, abuse of children or pets, which is often another indicator of very severe abuse. A victim may not leave an abuser for fear of what he will do to children or pets. A victim may stay because she believes it's ultimately safer. Now, physical abuse, violence, that's often the most visible form of abuse. But victims often report that it's the other types of abuse that are actually harder to overcome. Emotional abuse can be very psychologically damaging. And then simple things like bad credit or lost employment or a false report to a police that can result in criminal records, deportations, the loss of children if CPS gets involved. Those are things that cannot be rectified. I should say that it is certainly true that violence is very important. It can lead to death. It does lead to death. In particular, when women are pregnant or have newborn children, that increases lethality risk. It's a particularly dangerous time for victims. On the one hand, just because there is some violence in a relationship, it doesn't necessarily mean that the relationship has domestic violence. You really have to look at this pattern of power and control. And usually if if this is a domestic violence relationship, there's going to be social isolation. There's going to be psychological abuse. There's going to be financial abuse. There's going to be many different things, not just physical violence. At the same time, not all abusers use physical violence. Often, either the mere threat of violence or the use of the other tactics I just mentioned is entirely sufficient to keep a victim intimidated and controlled. And physical violence, the abuser simply doesn't need to resort to that. Finally, batterers tend to present well. Often a batterer might be well-educated, smart, put together, employed. Victims may present very poorly, may appear very emotional, may not be capable of interacting well with authority figures, may have trauma responses, and could even have developed substance abuse problems in response to trying to deal with the abuse. So finally, this begs the question, why don't victims leave? The short answer is a lot of victims do leave, but it's hard. And partly this goes to the cycle of domestic violence. There is a cycle. Often there's within abuser and victim, there's a buildup of stress. There's a trigger or a release of that stress resulting in an incident, whether it be violence or not. And then there'll be a honeymoon period. And these cycles can occur with any frequency, once a day, once a year, once a month. Victims also often stay because of that honeymoon period, because they want the abuser to change, because he is the father of their children. But at the same time, victims often stay because they have no other choice. At this point, they might have no family, no friends, no money, no car, no housing, no job. There's no way for them to leave. And then finally, victims may stay because they believe it is truly safer for them to stay. If they stay, he will kill her. He will kill her and the children. Or sorry, if she leaves, he will kill her or kill her and the children. If she stays, she might be able to at least direct his violence towards her rather than the children, or may be able to placate or moderate the violence in other ways. As a final note, separating from an abuser is the most dangerous time for a victim. That is when everyone goes on high alert. And most victims try and leave multiple times before they're ultimately successful in leaving an abuser. So now I'm going to turn to the second part of my presentation, which is what is the Family Violence Appellate Project? It's known as FVAP for short, and it's a nonprofit legal organization based in Oakland that serves all of California and recently expanded to Washington State. Its primary focus is on family law with a secondary focus on dependency, but its goal is to end the intergenerational cycle of violence, specifically through working with and improving our legal systems, both at the trial court levels, that means family court and dependency court, and at the appellate level, which means asking the Court of Appeal in California to step in and either affirm or reverse trial court decisions in order to help further protect domestic violence victims. It's a pretty new organization. It was founded in 2012 by two UC Berkeley law students. And the whole idea behind FVAP is that the California legislature is one of the most progressive legislatures in the world. We have some really good laws on the books to protect domestic violence victims, but they're not being enforced in trial court. Not all of them, but some of them. And so FVAP was founded to be like, hey, there needs to be some organization here to try and encourage trial court judges to actually apply these laws and to apply them in the right ways, the way the legislature intended to protect victims. And sometimes that means appealing those decisions and getting the Court of Appeal to tell trial judges, hey, you got something wrong. Or sometimes in cases, hey, you got something right, especially when an abuser appeals a trial court decision that went against him. In terms of dependency, FVAP will step in, will file amicus briefs in certain dependency appeals, and we will also request publication of unpublished Court of Appeals cases that we believe will move dependency case law forward, will better protect victims of domestic violence. So now I don't have that much time, but I'm going to turn to finally what are where does FVAP come from? What's most important in terms of child welfare and the dependency system? We would like to see more children kept with non-offending survivor parents. Children should not be physically removed from victim parents unless it is absolutely necessary. Children who have witnessed or experienced domestic violence in the home have already undergone a lot of trauma. And by removing them from the protective parent, the only parent that has stood up for them, have helped them, is a mother or a father, is doing additional harm above and beyond what they went through by experiencing that domestic violence. How does this come up? Where do we see this in domestic violence cases? We typically see this where the non-offending victim parent is alleged to have failed to protect the child. A dependency court will come in and take jurisdiction over a child based on certain statutes in the Welfare and Institutions Code. And one of them is if you fail to protect a child from dangerous behavior from another person or a custodian. And often, ultimately, that children are removed from a victim parent because the child welfare agency alleges and the dependency judge agrees that the victim parent failed to protect the child from witnessing domestic violence. So this doesn't comport with what is best for children. And we believe that there should not be jurisdiction over victim parents for failure to protect from domestic violence in and of itself. Failure to protect from actual physical abuse or sexual abuse is another matter, and that certainly should still be in the law. But the current practice of removing parents from failure to protect has a whole host of bad consequences. Often, number one, it often promotes an incorrect understanding of domestic violence that's limited to physical violence. Social workers typically don't see all of the other tactics that I mentioned above. They're only responding to physical violence. It punishes the victim parent. It's based on this incorrect assumption that domestic violence is a mutual event, that both parties are equally responsible and they both control the conduct. The victim parent may have not been able to protect the child, and now she's alleged to have failed to protect the child. The victim parent may indeed have protected the child by, say, taking an abuser's violence and directing them at her and not the child. But again, she's alleged to have failed to protect the child. It punishes a victim parent for reporting abuse, and this is really, really important. If a victim parent calls the police to report the violence, the police often will cross-report to CPS. Then there's a danger, a dependency is instituted, and the survivor is going to be separated from her children. And she may be separated even at the same time when the prosecution is requiring her to testify. Abusers know this, by the way, and they will tell a victim, oh, don't call the police. You call the police, the second you call the police, CPS will be out here and your kids will be taken away. And so this is a real big consideration. What that ultimately means is having this failure to protect case law in here or statute, it dissuades victims from coming forward or reporting abuse. And then when the victim doesn't report the abuse, when the victim doesn't call the police and someone else does, the victim is still separated from the children because the authorities do get called in and she's told she should have called the police. It's a catch-22 and there's no way for a survivor to act that does not put them at risk. And then ultimately, and I think this is a point often lost, is failure to protect punishes the children for the acts of the abuser. You know, if a child is, and I already said this before, but I'm going to say it again, it's punishing the children. The child is removed from the only protective parent they've known and placed in a in the foster care system. That's simply not right. It's not in the best interest of the child. It is fundamentally damaging. And then finally, failure to protect jurisdiction. When dependency courts come in, they're really only supposed to remove a child or even assume jurisdiction over a child if there's a current risk of harm to the child. And often what happens is that there may have been domestic violence in this family, but the victim, by the time it gets to dependency court, has left, has separated. Maybe she's got a restraining order. Maybe she's in a shelter. Maybe she hasn't seen the abuser for 4 months, et cetera. And yet the dependency court still assumes jurisdiction over that child, still says there's a current risk of harm. When the victim's like, I separated, I did everything you asked me to do. I am now in a shelter, I have a restraining order, I'm cooperating with the prosecution, and you are still telling me that I failed to protect my child? That does not exactly convince victims to trust, government authorities or agencies in the future. So if we are going to maintain this failure to protect language as it is currently now in the law, there needs to be more of an emphasis on current risk to the child. Just because there is past harm does not mean that there will be future harm. And often I've seen both judges and child welfare agencies use the fact that, as I mentioned before, the cycle of violence is a well-documented fact in DV relationships, to argue that, oh, well, the victim's only been separated 2 months. She's going to go back to him. So therefore, we have to step in and we have to assume jurisdiction or remove the child because we don't know if that cycle's broken. Not the right way of thinking about it. There are plenty of other ways a child welfare agency can informally supervise a family. And taking jurisdiction or removing a child from a parent should be drastic measures that are only taken under extreme circumstances. I have plenty of other comments, but my time is up. I'm happy to take questions. I will note that I will have to sign off at 11 a.m. And the two next panelists will be discussing in much more detail additional problems with the dependency system. Thank you so much.
Thank you so much, Anya, for your testimony. You touched on a lot of issues that are really significant. First, the power and control that you discussed. I'd like to take a moment every single time when I do talks on domestic violence just to highlight everything that you address in terms of power and control and how we have this misconception of what is domestic violence. And a lot of times it's the power and control that happens before the physical assault, by way of example, either choosing who the friends are, isolating people from their family and friends. And so I always like to tell parents, if they're listening, we used to ask teenagers, have you been assaulted? Has your boyfriend or significant other assaulted you? But I think we need to change the way we address that and also ask, is your boyfriend or girlfriend coercing you? Are they choosing your friends for you? Are they taking your phones away from you? So I'd like to just put that out there because it's important to note the coercion happens way before the physical assault. So thank you for everything that you shared, and I think it's important to note that we have to change our mindset on what is domestic violence. And I also appreciate the fact that you brought failure to protect, which is an issue that I've been trying to delve into and resolve. I think that we shouldn't be traumatizing a victim twice, first by the assault, secondly, by removing a child that should be with the non-abusive parent. And so we definitely need to look into it. I want to turn it over to Senator Skinner. Any comments, questions?
Thank you. I'm going to just ask one quick question. I obviously am really interested in this, the point you made, Anya, about the failure to protect and how that hurts the children, punishes the children and the victim. So definitely we'll talk more with my chair about how we might pursue trying to fix that. But the other line I wanted to just ask now, it's not the focus of the hearing per se, but it bears on all of this, is are our laws now adequate for dealing with this coercive aspect, this controlling aspect of domestic violence? Senator Rubio, for example, had a bill that I worked with her on, I think I was main co-author, but where we recognized that there was a lack of acknowledgement within our penal code and obviously within the law enforcement for the type of control or the type of domestic violence that doesn't leave physical scars, but is that controlling, that is very extraordinarily damaging. And so I wondered if you felt that we have adequately fixed our penal code to recognize that part of domestic violence.
Thank you, Senator Skinner, for that question. I am going to have to get back to you because that is an excellent question, and I need to look into it further. I didn't review that right before the hearing this morning, shall we say.
No worries. I think both the chair and I are interested in that for the future, and I think that what we, I mean, look, you can't, it's abusers, whatever, there's lots of tools they can use, but I think with things like social media now, the ability to more easily surveil your victim, the person you are trying to control, that there can be that many more forms of that controlling, coercive behavior. So I think, and yet it is easily, if not even more damaging than physical violence.
I will say that technological abuse, as you touched on, is rising, especially as the younger generation use technology more and more. And it is something that our law enforcement, of course, are generally ill-equipped to deal with. Whether that's because it requires computer forensics to trace, say, a damaging post back to an abuser's computer, or simply some technological know-how, it's often beyond most judges and abusers, and most judges and police officers. They simply lack the resources to investigate. And so I think the first thing that came to my mind when I heard your question is it's almost the laws we have on the books right now certainly can be improved, but it's on the ground enforcement. How are they going to get enforced? Who is going to enforce that? And I think that often judges and police officers and even CPS, they just look the other way. They can't deal with that. They can deal with a black eye. They cannot deal with a victim saying he posted, naked photos he took without my consent to Grindr, which happens all the time. And so there's an education component for the people on the ground. I think that today, the people on the ground, and I'm talking police officers and social workers, they know that domestic violence is bad. And that's great, because 40 years ago, we were not there. But they don't necessarily know that domestic violence is not just physical violence. So there's an education and training component. And then there's a resource component. Say there is terrible technological abuse, who's going to prosecute that? Right. Who's going to look into that? So I will get back to you on specific laws, but that was my takeaway.
So this is clearly a line of inquiry that we can pursue. We do not have to spend more time today because our hearing's a little different. But I think that we, in the course of the bill that the senator carried, Senator Rubio, the chair, we met women who, even after, so they were, in this case, it was one who was subjected to physical violence, but who then was able to have her abuser prosecuted for the physical violence, completely removed herself and her child from that, but then that abuser later was able to wipe out this woman's credit history, and plant things through hacking and such that were disparaging toward her, which then affected her career, affected her entire basically created long-term disastrous results, and which never were able to be, not able to be, but rather were not ever prosecuted. So the repercussions were even greater than the initial circumstance. But anyway, it's a line of area that we obviously have to pursue separately, but any information would be helpful. And I think the education probably is the important part.
Well, the one thing I will say in response to that is when when a family does enter the dependency system and the victim is trying to go through reunification to try and get her child back, what you often see is that batterers will sabotage that process. For instance, if she needs to establish independent housing and a job to get her kid back, or at least to be stable enough to do all the other requirements that the court's requiring her, if her credit is ruined and he gets her fired from the job, that can really sabotage a victim's attempts to get the child back. So it actually does come up in dependency more often than you would think.
So, thank you so much for that. I just want to add just real quickly, so the bill that I passed with the help of Senator Skinner was SB 1141, which defines coercive control. And I do know, based on all the messages I received from victims consistently, it's still a challenge to have courts recognize it, understand it, and so the education piece is important and the enforcement piece is also important. I want to welcome our colleague and Senator Ana Caballero, who has just joined us. Welcome. Thank you for your testimony, but now I will turn it over to Senator Caballero for any comments or opening remarks.
Well, I just want to thank the chair very much for scheduling this select committee hearing. Really important topic, and it's my understanding that the informal data indicates that domestic violence has been on the rise during the coronavirus pandemic, and so we need to be prepared to be able to offer assistance to those individuals that are interested in leaving an abusive relationship, so that they have the resources and so that our community has the resources to be able to respond. So thank you very much to the chair for this opportunity to participate in this hearing.
Thank you. Next, we will now move on to our next panelist, Julie McCormick with the Children's Law Center. She's a senior policy attorney at Children's Law Center of California. She is also practicing family law has been practicing family law for over a decade, both in the private and non-private sector. Julie has also worked on policy and legislation impacting commercially sexually exploited children in California. Thank you for joining us. You have the floor.
Thank you, Chair Rubio and honorable members, for shedding light on this critical issue and for providing this opportunity for us to speak to you. First, let me explain. Children's Law Center of California, the organization I work for, represents approximately 35,000 children and youth in Los Angeles, Sacramento, and Placer foster care systems. I was a case-carrying attorney for this organization for about 7 years, so did direct representation for hundreds of children and youth. Prior to that, I did practice in family law, and worked for a domestic violence organization that focused on teens and dating violence, the education and legal representation of those youth. And so we want to talk today. I appreciate Anya for laying some groundwork and talking a bit about dependency and the general overview of domestic violence. My testimony today is going to be focused on, again, a general overview of the dependency court system, the impact of domestic violence on children, the things that we see when these children and youth come into our child welfare system. I then want to look at the child welfare interventions impact on children and families and sort of the things that we see as problems and what we believe or what are some of the possible solutions going forward. So very briefly, dependency court, the child welfare system, you'll hear we have a parents council coming on after me that will get more into the legal framework, a little more into the welfare and institutions code. But the overview of the dependency system, cases come into our system when a referral of abuse or neglect comes in. And that call can come from law enforcement, a medical provider, a teacher, domestic violence counselor, a shelter. As Anya mentioned, it can come from the abuser themselves, or it can come from the victim. And I think what we see is when someone is seeking out help, that is somehow, that's when they then find themselves entwined in another system. So they've gone to a counselor, they've gone to a shelter seeking help, and then a referral is made to this child welfare system. Those referrals are then investigated, and if they are substantiated, a case is filed with our court, with the dependency court. And under California state law, the state will then get an attorney, the parent has an attorney, and the child has a right to an attorney. And that's what the Children's Law Center does. We represent the child, ensuring that their voice is heard, also ensuring that their mental health, educational needs are being met during the time they fall under our system. One of the issues we have seen is there really is a lack of good, solid data as it relates to the intersection of child abuse and domestic violence. Anya briefly mentioned there's this WIC code, the Welfare and Institutions Code 300B, and that is our neglect statute. Now, when a case comes in under that statute, it's very broad. It can fall under general neglect. It could be a mental health issue that the parent is experiencing. It could be substance abuse. And from our experience, a large number of those cases do come in due to domestic violence. And when they come in, what the law anticipates is that the system is going to provide reasonable services to the parents or the parent to prevent removal. However, because of a lack of resources or a disconnect between the child welfare and the domestic violence community, we see that many of these cases lead to the children being removed. So what we want to talk about is what we're going to hear a lot today is what the system is doing wrong, and that it is punitive to parents, which we do not disagree with. However, we'd like to first establish that there can be an ongoing risk to a child in a home with domestic violence. So we've seen there are studies, the impact of domestic violence on children. There's potential risks, the physical risks. Studies show in homes where violence between partners occurs, children are at increased risk of being abused. They also can experience physical health problems, including generalized anxiety, sleeplessness, nightmares, difficulty concentrating, high activity levels, increased aggression, increased anxiety about being separated from a parent, or even intense worry about their safety or the safety of the parent that is being abused. We've also seen that there can be long-term physical health problems, and then behavior problems that develop into adolescence. Studies have shown that children that have experienced domestic violence in the home can have a higher incidence of delinquency involvement. They can be 74% more likely to commit a violent crime, 50% more likely to abuse drugs or alcohol, 2 times more likely to repeat the cycle of domestic violence. And I think as Anya mentioned, their organization, their goal is to stop the intergeneration cycle of violence. So we do see a great concern for children that are witnessing domestic violence if they are likely to repeat that cycle. They also can experience emotional difficulties in adulthood. We've seen increase in depression, anxiety disorders, and post-traumatic stress disorder. So clearly, there are undoubtedly situations where intervention is needed, given all these increased risks. However, what we're seeing is the system response currently is hugely detrimental to families. There's sort of a one-size-fits-all, and I believe the panelist after me, Brian's going to address that more. But really, in the system, violence can be caused by a range of issues. And while Anya, focused on the power control of domestic violence, and that is something that we do see, we also see families that are experiencing poverty or homelessness or substance abuse or mental health. And instead of addressing those issues, it's sort of a one-size-fits-all, remove the child from the harm and not giving the family the supports needed to either address their underlying problems, whether that be support with housing or mental health, or getting them into a substance abuse treatment program, or addressing underlying trauma and relationship issues. So these intertwined issues of homelessness and poverty really play a great part in a lot of the cases that we see come before our courts. And I think that's one thing that we wanted to focus on is the myriad of reasons that a domestic violence case could come in and how right now the supports are not being provided. What should happen, as I mentioned, there's a reasonable service requirement. The law requires that before a family is separated, they should be provided services to eliminate the risk. Oftentimes there are great barriers. So when a victim is being told that they're failing to protect because they have not removed themselves from the situation, but as we know, housing can be a huge barrier. Telling a woman to leave with maybe all that's available is a shelter that can only keep her and her children there for a few weeks, or there's some financial barriers and where the job is, language barriers we see immigration barriers. And the current process really takes away the victim's power. They're extremely prescriptive plans that it's, again, this one size fits all, that this is what's happening. Okay, you need to immediately leave the abuser, leave everything that you know, without really addressing what their needs are and what supports can be given to them. One example we often encounter in our practice here, because we do represent youth who are also parents themselves. So some of our older teenage clients are themselves parenting, and they do find themselves in relationships where violence is an issue. But instead of teaching them about healthy relationships or addressing their own trauma, again, we go to that one size fits all solution, which is to remove their children. But that's not addressing sort of the supports they need, the development of healthy, respectful, nonviolent relationships, teaching teenagers how to maintain a healthy relationship and developing skills about managing their feelings or communicating in a healthy way, focusing on prevention measures, like having support system from their peers and their families. And really, again, just not looking to what the victim needs, what the family needs. And again, looking at, so where are the areas that we can improve? And we do feel that one of the reasons we're not addressing this issue as well as we can be is a lack of training and knowledge on domestic violence. For the child welfare system, recognizing domestic violence. Again, our first presenter, Anya, talked about the different types and that many people immediately go to physical violence, not understanding that there can be financial or emotional or, as the bill Senator Rubio put forward, the coercive control issues. So if we're failing to even recognize the types of domestic violence, the different forms of it, how can we be sure that we're providing the correct resources, that we even are aware of what resources exist, and then how to make an individualized assessment of what families need to move forward. And this training and knowledge and understanding needs to be by the entire system. We're talking about attorneys, social workers, and our judicial officers. One area where the Children's Law Center is beginning to focus is traumatic brain injury. We're learning that many victims of domestic violence have incurred traumatic brain injuries, which can have a physiological effect for some period after that injury. And instead of recognizing signs of this traumatic brain injury, as Anya had mentioned, it impacts how we look at a victim. We look at the way that they're presenting and that they are uninvolved and don't care about the child, that there's an apathy or an unwillingness to engage in services when there may be this underlying medical condition, and the physical impact of a traumatic brain injury and how it might manifest as a failure to comply, or what we've heard about the failure to protect. We're starting a pilot actually here to collect data. We're going to be screening our commercially sexually exploited children and our pregnant and parenting youth for traumatic brain injuries, sustained from interpersonal violence. Our attempt is going to be to gather resources and providers to further support education and advocacy for our clients and courts and counsel, with the goal to be to create individualized case plans that are more aligned with brain trauma in hopes of improving outcomes. This goes back to the further, instead of like providing true prevention and intervention services, often the response we see is to remove the children and place them into foster care. So while I discussed previously the harm that can come to the children by being in a home with domestic violence, I want to talk a little bit about the harm to the family and to the child from child welfare intervention. And this is the system that's coming in to protect. So we'll hear more from other advocates, but the harm to the family is the victim being punished. And I believe Anya covered that a lot, but when they're reaching out for help and then they find themselves in the child welfare system being punished for seeking that help. Services can be extremely overwhelming and they are not paid for. So we set up these programs for the families to participate in, whether that be a batter's intervention program or parenting or counseling. Getting to those services can be difficult, and they're, a financial burden to these families who are already experiencing maybe the loss, if they've had to move out, the loss of some financial support. These families can sometimes lose benefits when their children are removed. And as I said, trying to keep up with all the court mandated programs. And then another one that we see, and I don't believe has been touched upon, but we oftentimes penalize families if there's any expressed intent to remain together as a family. And there are situations where if services and supports are put in place, this may be what is best for that family, and asking that family what they need. So the assumption is victims should immediately leave the abuser, or there's a failure to protect, where then there might be an individualized way to better support the family. And then the harm to children, when the intervention of the child welfare system comes in, and where we just come in and remove the child, that's the trauma from separation. We need to address the harm to children in a home with domestic violence, but it's really important to also address the home to being removed and placed in foster care. And this shouldn't be a debate about what is worse. We don't want to do a balance of harms in that way. We should be working on how we can fix it. So looking at what happens to these families and how can we better support them by providing protection to the child and to the victim, but also ensuring that the supports that are needed are provided to them. I believe I'm getting the signal that I'm running out of time. So I just want to thank you all for your time and addressing this issue. And I really look forward to continuing to work with you. Thank you.
Thank you very much for that testimony, Julie. I will now turn it over to our members for any questions or comments. We'll start with Senator Caballero.
Thank you very much, Madam Chair. And I want to thank the panelists for their testimony here today. It's important to take this opportunity to have discussions about how we can ensure that the system works better, not only for the victims, for lack of a better word, that are fleeing domestic violence, but also their children. We know that that trauma, it's probably almost as difficult for children to experience the domestic violence as the victim themselves, and many of them carry it with them their entire life. And I'm wondering if the system that has been set up, I'm not even sure that if every single county has a CASA program that provides assistance to an ear, if you will, that's not involved in the outcome of any proceeding to the children, whether that's a valuable source or resource, and what are the solutions to trying to provide some assistance to the children and to make sure that they're heard in a courtroom setting as well?
Senator Caballero, that was directed towards me.
I believe so, yes.
Okay. And as far as CASAs in LA County and Sacramento County and the counties we practice in, we do have CASAs and we do utilize them. And to make it clear, as attorneys for the children, we are the voice of the children. So we do interview the children, we do independent investigations, and we bring that voice to the court. Obviously, depending on the child's age, that varies. We do have to, without getting too technical, Minors Council in California hold a dual role where we look at the child's best interest as well as their stated interest. And that can depend, obviously on the age of the child. So we are there as a voice of the child. CASA is obviously a great resource and can be assigned on a case-by-case basis so that youth can have another outlet. But we are that voice. We do the independent investigations. I think the solutions that we're sort of looking at and was addressed by our first panelist is in the failure to protect realm. And just more so, just not having this one size fits all, that we are looking at the family and what they need, and that when someone reaches out for help, that there is not a punitive effect, that we are really coming together to support. And I think just the way that the current neglect statute is written and sort of how it's been implemented more so, those supports aren't always put in place. And obviously at the forefront, we want to protect children from harm. We want to protect families. But sometimes where you go to, your immediate reaction is just remove and separate without taking into account the additional trauma that is being put on that child from that separation.
Got it. I guess my concern is that not every family enters the court system in the same way. And I haven't practiced law for a few years now. But when I did, when I had my own law practice, I took 300 and 600 cases court appointed and represented parents and children, depending on the language ability of the parents. Many times I was appointed to because I spoke Spanish. But my real concern is that when you're court appointed, it's usually because a child is already going to be removed from the home. And the ones that I didn't get court appointed on were the ones that went through the divorce or the domestic violence system that didn't end up as part of a 300 or a 600 case. And so, and those children many times were not represented in court. It was the parents fighting it out, or the or the victim. If there was never a divorce proceeding or a custody proceeding, the kids' wishes were never really taken into account. And I guess the system is a complicated system depending on how you enter it. And and the more flexibility we give to judges, the more difference in treatment you see. And so we're in I think our interest is making sure that we're protecting the interests of the child and the victims, and that there's a system in place to be able to provide them with the supports that they need. And I didn't always see that in the court. I guess that's my biggest concern.
Yes. Yeah, and if I can briefly address that, I was a family law attorney, and that was actually one of my issues. Was I wasn't seeing children, have a voice, except in very limited situations where a minors counsel was appointed, but that was rare. And it is one of the reasons I am at an organization where every child has a voice. But I think one thing, and I don't know that we touched on it, but is in the beginning, is sort of the prevention services, is working with systems that come into contact with these families to prevent sort of the filings of these cases in child welfare system, or to help families even in the family law system. So it's putting in those prevention services and supports that, would, I guess, provide a way that, we'd like to see the issues addressed before they have to even come under our system. I realize in the family law system, that's a little different, but I think it comes to, better training for our social workers and for those that are coming into contact with these families. I think we've heard today just the variety of ways that domestic violence can manifest, and many people aren't aware of that. So being able to address this in a preventative manner early on.
I appreciate that. That's really, I guess, what I was getting to, is the support services, so that we don't end up in the system, or so families don't end up in the system if they can avoid it. They can make the decisions for themselves without having to go to court and fight it out in front of a judge. Thank you.
Thank you. I will now turn it over to Senator Skinner.
I'll pass on questions this time.
Thank you. So I want to thank you for your testimony. That was Really enlightening, and I think you touched on something that just caught my attention, which is the intergenerational violence and what happens to those victims, the children impacted by domestic violence. And I know that, being a teacher for 17 years, usually I can spot a child that's been experiencing some trauma in the home, because you start seeing some of the changes in academic grades and changes in behavior. And so one of my biggest concerns and challenges is what you stated. When you remove a child from a domestic violence home, they don't have necessarily a good model of what a healthy relationship is. They don't have any other examples. So I guess it's something that I think we need to explore a little further. How do we get those services to those children impacted by domestic violence? How do we get them to understand what a healthy relationship is? And so it's something that I would just keep in the back of my mind, and hopefully we can figure out how to change that behavior so it doesn't continue generationally. So thank you for that. So now we will move over to our next presenter. Next is Brian Okamoto. Mr. Okamoto is a public defender in Orange County and has been for 18 years. And Brian also serves as a member of the Juvenile Court Professional Development Committee. The floor is yours. Welcome.
Thank you so much for that, Senator, and thank you so much for hosting this forum so that we can share our experiences, and I appreciate your open-mindedness to it all. I also want to thank the previous presenters. Their information is absolutely enlightening. There is some overlap with mine, and I'll try not to overlap too much, but I think what it will do is it will underscore the importance of those points, that even though we all three have different perspectives, we're all seeing the same things, and I think that's telling. And so my name is Brian Okamoto. I am a public defender in Orange County. I did criminal law for 15 years. I'm now in dependency, and I've been here for about 4, where I represent parents. The law is obviously different here than in crim, but the population we serve is the same. The population I serve here are parents who struggle with abject poverty, substance use issues, domestic violence, mental health, and often these symptoms that we see are exacerbated by the child welfare system that removes children. So what I want to talk about today are basically 2 things. One, I don't want to go over too much in the law. I think that's been covered, but I did want to touch upon that. But also to describe, from my point of view, how the system actually works. And I hope that as I talk about these topics, that a few points really come to light. One is that the statutes and standards of review that govern our decisions on domestic violence here in dependency are susceptible to biases and misguided preconceptions. And they do allow for punitive and sometimes oversimplified reactions that can punish not just the offending parent, but the abused parent as well, and even the child. And I think the previous panelists have addressed that. 2, that domestic violence is complex and nuanced. And Julie touched upon this already, and that we shouldn't be addressing these families in dependency courts with a one-size-fits-all approach. And that's not just as the determinations that we make in courts, such as whether or not we assert jurisdiction or remove children or return children, but it also has to do with how we provide services to these families. We should not have a one-size-fits-all approach to that as well. And third, that there have been recent appellate opinions in 2020 and 2021 on domestic violence and dependency. And while those opinions are extremely encouraging because they're bringing to light a lot of the research on domestic violence and giving us a more accurate view on that, they're also concerning because these are recent opinions and those decisions are based on the arguments and decisions made in our trial courts. And what they do is they reveal that our system here sometimes will operate on a misguided culture, a misunderstanding of domestic violence, and that there is a need for education and reform. And so I appreciate this opportunity. And let me just jump in. So Julie mentioned that I would be touching upon Section 300B, and I know that Anya already addressed that as well. So this is jurisdiction. When a court takes jurisdiction over a case, the court here in dependency takes jurisdiction over the child, not the parents. And the purpose of dependency is not to punish parents, but to protect children and to reunify families. Those are our mandates. So 300B is the code section that we refer to as the failure to protect statute. basically three elements the court's looking for. One, is the parent unable to provide necessary supervision or protection of the child? And causation with, that's two. 3, serious physical harm or illness or substantial risk of either. So what does this mean when we think about burden, right? So is this a high burden? It's arguably, it would be, right? Because we're not talking about any kind of risk. We're talking about a substantial risk, right? And we're not talking about any kind of physical harm or illness. We're talking about serious physical harm or illness. Now, what exactly do these terms mean, substantial or serious? Now, where is that line for domestic violence when it is a risk versus a serious risk, where there's a substantial risk or just a regular risk? Who makes those determinations? Because the code doesn't provide us a clear definition on where that line is. So the answer to that, on who provides this line, is us. It's the practitioners. It's the judges. It's the social workers. All of us are the ones that are trying to apply this standard in the most uniform way possible. But we're humans, and we all bring forth our understandings or interpretations of circumstances, facts, and yes, domestic violence. And that should be concerning sometimes. But the role of the social worker is absolutely critical as well, because the social worker is making recommendations to the court whether or not we should assert jurisdiction, whether or not we should remove children from parents. The social workers are giving these recommendations, and they're given great weight by the judge, right? Because social workers are deemed as impartial arms of the court. In fact, hearsay is admissible in the social worker reports because of their recognized professionalism, that they're reliable and that they're unbiased. So it is absolutely critical that everyone in our system, and especially the social workers involved, are up to date and aware of domestic violence. And they have an accurate understanding of that because the recommendations carry great weight in our courts. So, and if we as practitioners, judges, and social workers don't fully realize the realities of domestic violence, then oftentimes what we'll do is we'll rely on hunches and preconceptions. And that makes us prone to making erroneous decisions for families on important issues, like whether or not we should reunify a family or to separate a child from the parents, right? Inflict further trauma on children, and worst case scenario, even termination of parental rights. So in practice, what does it look like? Well, you've heard both panelists talk about failure to protect in this scenario where we could sometimes actually remove a child from an abused parent. And I've had situations where I've had conversations with my client where that is being discussed, and we're on the brink of the court removing the child from that parent's care. That parent looks at me confused, wondering why, having just been abused, the court would take away my child. Why would the court respond to that trauma with additional trauma by removing that child? It's absolutely traumatic for the child. It's actually, and it's traumatic for that parent as well. The parent doesn't understand how the system would want to place that child in a stranger's home or a cottage with other strangers, and the child not knowing when he or she is going to go back to the parent, and especially at this frightening time after domestic violence has occurred. These are real concerns that we have in our system. And I know there's been some debate on this topic and how we should properly word this, but I think as a starting point, we need to recognize that we need to pause before we do something like this. We should have guidelines in place to prevent this or make it more difficult. I know it's been discussed, but I think if we all focus on the trauma that both children and parents suffer from this removal under these circumstances, that we can come to a consensus in some way. And so I absolutely applaud Senator Rubio and everyone's efforts to get something passed on this. And I'm grateful for the voices before me that spoke on this as well. So it's been talked about by Julie about our concern about the one-size-fits-all approach in dependency when it comes to domestic violence. That is front and center one of my main concerns, because the easier cases, maybe not easier, but the obvious cases are those where we see clearly who the abuser is and who the abuse is. But sometimes it's not so crystal clear. And we have to recognize that domestic violence can be exhibited in different ways. There are patterns and cycles of violence, but there are also different degrees of that. And there are times we absolutely need to intervene and remove children, but there are also times when we shouldn't even exercise jurisdiction in a case. And it's those nuances that I think sometimes get lost when we approach domestic violence with this one-size-fits-all approach. We overreact to some circumstances when we shouldn't have to, and we end up traumatizing children in the process. And so what does that look like? Well, I want to talk about these appellate opinions because that way it's not just me spouting out some of the things that I've experienced in my caseloads. You can look at the court opinions and see what occurred. In Re Cole L. is a 2021 case. It just came down recently. And in this case, the Court of Appeal found that the juvenile court erred in finding jurisdiction. And there, the juvenile court found that there was jurisdiction under 300B because of the parents' long history of domestic violence issues and the mother's refusal to participate in services. But these services weren't ordered. And there was no evidence of multiple acts of domestic violence over an extended period of time. In fact, there was one incident. It was an incident involving pushing and shoving and grabbing over a cell phone that occurred 9 months prior to the hearing. So 9 months, the mother lived with the child with no problems. There was no acts of domestic violence. The father's whereabouts were unknown, and mom maintained a restraining order. The Court of Appeals dismissed this petition. And so what it said, look, we can applaud the Court of Appeals for making this decision, but we have to recognize also that the trial court made a decision for jurisdiction without supporting evidence. And that is just one case. There are others. So, and it begs the question then, like, what exactly is domestic violence then that would support jurisdiction? And what is exactly domestic violence? We sometimes answer this with our expectations and our preconceptions that with this one-size-fits-all approach, we think a victim must look a certain way or behave a certain way. If the victim mother is not doing services, that means she doesn't care, right? If she's not soft-spoken or seemingly frightened, then we assume that she might be just more aggressive or more difficult. There is not a one-size-fits-all approach to this. And I think Anya mentioned this, that sometimes that batterers can be really sophisticated and they can and win over social workers and judges. They can be charismatic, relate to authority figures, and they can get the advantage in these courts over someone we're overlooking as the true victim. So there are some examples of this, of how we have these expectations for roles. Inmate IB is a 2020 case. This is an example of the role of a so-called victim isn't really clear. The case came in because the mother lashed out at her abuser by throwing something at him. But later it was revealed that the father had jealous rages to isolate her, physical abuse to anger her, verbal abuse to harm her self-esteem and independence, and taunted her knowingly, knowing that it would trigger a physical reaction. So it's not always clear, and we should avoid making snap judgments on this. And what do we expect victims to act like? So in a case in Re Ma V, which is also a 2020 case in my jurisdiction, in that case, the juvenile court focused on mother's past as a victim of domestic violence and noted that she was uncooperative with social services. And despite being 10 months free from the father, the court still took issue with mom. The Court of Appeals recognized and stated this actually, that there was a recent and troubling trend of what they perceive as mothers being victims of domestic violence. And they added this quote: "We expect such victims to be sweet, kind, demure, blameless, frightened, and helpless, and not a multifaceted woman who may or may not experience fear or anger. These are the preconceptions that judges and jurors bring with them into the courtroom when they assess the veracity of a victim witness story. We encourage continued diligence and education to guard against such preconceptions." So what else do we do when we impose our expectations? We have this expectation that in order to reunify the family or close the case or allow the children to remain with the so-called non-offending parent, the parent has to demonstrate a period of separation from the abuser. But that's also a nebulous concept, because how long does the parent have to be separated? from the abuser. In a case, in that case, NRA IB, that 2020 case, in that case, the juvenile court found that 8 months of separation just wasn't enough. And again, relied on the history of domestic violence. And the arguments in there were quite shocking. Both Minors Counsel and the County Counsel for Social Services argued that there was, quote, no true change of circumstances because of mother's history, and that her past failures to separate herself from the father were conclusive proof that the abusive relationship would persist. And one even argued that the mother's, quote, compulsive involvement with the father had not ceased. And this, the Court of Appeal took issue with and said that there's a shocking lack of understanding about survivors of domestic violence. Terms such as compulsive involvement perpetuate the myth of the helpless, weak, battered woman. This is, again, an example of us imposing our expectations on how survivors need to act before we either return their children, close cases, or assert jurisdiction. And we can be misguided on this when we bring those standards in and we don't apply standards that we should be applying. But again, because those terms like substantial risk, serious physical harm are quite nebulous, it does leave room for some of these interpretations. Fortunately, the courts of appeal have been vigilant and have assisted on this. So what standards should govern? Again, substantial risk, serious physical harm, these are nebulous terms. And sometimes what we have to do in dependency, especially when we're assessing substantial risk, is somewhat like predicting, almost like gazing into a crystal ball and trying to guess whether or not there is going to be a risk, right? Angie versus Superior Court, also a 2020 case. The family was at the 18-month review, meaning at that review, this is a statutory status review. The expectation is that the children go home unless there is evidence of a substantial risk of detriment. Here, again, there's that word substantial, right? Here, the social worker opined that the parents hadn't resolved their domestic violence issues, and the court adopted the recommendation and terminated services. And by the way, when services are terminated, the case is now on the doorstep to termination of parental rights in many instances. The thing here, though, is both parents fully participated in their service plans. Mother had a substance abuse issue at the beginning of the case that the court acknowledged was no longer a concern, but the social worker testified. Her concern was that the parents continued to interact with each other, even though the social worker encouraged the parents to interact and co-parent. But the court was still concerned with mother's relationship with her domestic violence boyfriend, not the dad. A therapist for the mother opined that there were no concerns about this relationship, and there was no contradicting evidence. The court still found that the boyfriend posed risk to mother's sobriety, even after acknowledging that mother didn't have any, there were no concerns about mom's sobriety. As to the dad in the case, the court found that he lacked insight, but didn't say what evidence supported that finding of lack of insight. And then also noted that the parents seemed to linger in their relationship, but there was no evidence that they maintained the relationship. The Court of Appeals reversed this as well. It could be seen as a victory, but the family had to wait 5 months for that decision to happen. They would now have to recover and rebuild some of those relationships. So,
Sorry
how do we determine?
To interrupt, we have about 2 more minutes. You make.
Let me wrap up. Thank you for that. Okay, so one concern that we have are formulaic responses to domestic violence, where we just basically say, here's a DV case, bad dad move out, mom get the kid back, participate in your personal empowerment program, dad go do your services, we'll keep the family separated, then we'll close the case with exit orders. But what we've done there is we've separated the family, we haven't reunified them. And the services that we provide, are we really trying to bring the families back together again? Are we just giving straightforward services like general services like classes instead of individual therapy and counseling? So what should we be? I think we need to continue to focus on our mandate of reunification, not separate families and keep the parents separated. There are times we have to, but there are times we should also be trying to bring that family back together again because they need to co-parent. And the child does need both parents in his or her life in some instances. The services, we need to get to the root causes and not just the symptoms of domestic violence, root causes like poverty and depression, and even the parent's own past trauma. I'm not naive to believe that we can solve every case, but it doesn't mean that we should deem every case hopeless. And lastly, these cases, these appellate cases do give me hope because there's recognition now on what domestic violence really is. And we have law that we can cite. But still, it frightens me because these decisions are based on what's occurring in our courts. Our court system, I think, is making improvements. We still have room to grow. And I believe right now we're at a pivotal point where there's interest for that. And I believe that we should strike while the iron is hot. I don't have the answers for everything. I know there's not just one answer. And I know I have to do my part to make sure that the system works and be informed. And I'm still open to learning from the other panelists and these senators. I'm comforted in knowing that the other panelists who are far more informed than I am are here today amplifying these concerns, and that we're not just expressing these to judges who have their minds made up, but to you, senators and members of the public that care earnestly about this population that we serve. I'm so grateful for you, Senator Rubio, and to all of you for convening this hearing. And I know I speak for all of us panelists. We appreciate your partnership in caring for the communities we serve. Thank you.
Thank you for your testimony. I will now turn it over to members of the panel. I'm sorry, the committee members. Any questions?
I don't have a question per se. I mean, that was a lot that you conveyed. What I would appreciate, however, many of us taking notes, we obviously have our staff here, but if you were willing to send us in an email a few of the concrete recommendations that, based on what you've been observing in your comments, that would be really, really helpful. Appreciate it.
Well, thank you, Senator.
Senator Caballero, any questions?
I just want to thank this gentleman, Mr. Okamoto, for his presentation. I've taken notes. If you've got the sites for those cases, that would be great. I'm struck by the comment about not having a formulaic approach, and so just seems to me we may want to have guidelines or guideposts. I didn't really practice in the civil area other than these court-appointed cases that I did. Most of my work was in the criminal defense area, but it just seems to me like the Judicial Council should have guidelines that they issue that gives some parameters around some of this. If that doesn't exist, maybe we need to ask that they produce that, because these court cases are appalling. It's great that they were overturned, but not to have facts upon which to start breaking up families that have been participating in processes and doing the best they can. I guess that's my concern. But the other thing is that I'm wondering if anybody's done any studies around implicit bias in the system. I practiced in mostly rural agricultural area, and frankly, the judges had no connection to most of the poor people that came in that were before them. And it seems to me that we're probably taking away children that are in really poor households more than not, number one. And number two, that many of the times it's the poverty indicators that would indicate the parents are not doing a very good job, or that would lead a judge to issue removal, as opposed to something else in the household that's happening. And so I'm very, very concerned that we have some parameters in this area, and whether we legislate it or we direct the Judicial Council to do it, whatever we need to do. I agree with Senator Skinner. We ought to, if you've got some recommendations, that'd be really helpful.
Thank you, Mr. Okamoto. I also will agree with my senator members here that if you can send us that information via email, any recommendations you may have, we'd be happy to explore it. And I personally do appreciate the concrete examples you provided for us to understand what's happening in the court system. First, I want to thank all the first panelists. We just concluded our first panel, which was focused on the overview of a child welfare and domestic violence in California court system. We will now move over to panel number 2, which will focus on improving outcomes for children, victims, and families experiencing domestic violence. We will start with Jonathan Wicks, who is from YWCA San Gabriel Valley. And Mr. Wicks is a trauma-informed care coordinator for the domestic violence program at the YWCA in San Gabriel Valley. The floor is yours. Welcome.
Hello. Thank you for having me today, Senators. It's really cool to be able to speak on this topic. Thank you for all the previous presenters. It was awesome to hear from you guys. I'm on the behavioral health, mental health side of things, but I do oftentimes help clients with the legal side of DV. So it's just refreshing to know that, like Brian said, we're all seeing the same things, even from my perspective. So I do have a unique perspective on DV. So I do our residential program, which we have 2 tracks. It's either a 45-day emergency program, but we also have our 6 to 12-month transitional program. So I do get to see and work with families through different time as they kind of move forward from their relationships, which we also have a non-residential program out of the main office, which we do support groups and individual work as well. And the reality is a lot of people, DV is so subjective depending on the family, and not everybody wants to leave their partner. So we do get a pretty good variety of different presenting challenges. And so I've learned a lot just from being here. I did my internship here in 2017, and they hired me after. So it's been a very insightful journey. And like I said, I'm just thankful to be here today to be able to talk about some things. So I know the goal for panel 2 is improving outcomes. So there is a good amount of preventative things that I wanted to talk about. Because again, with DV, it's one of those social issues that it is very much preventable. Like Brian said, though, not to be naive and expect it to go away completely, but there's a lot of work that could be done before families have to come into a program like ours, or, people grow up witnessing DV. There's work that could be done so that they don't also turn into a perpetrator. So one of the first things I wanted to talk about was trauma-informed care. And some of it, I think I'm seeing it right now in our own agency, is because we do have a turnover rate right now where we're getting new team members. And as they come on board, they also need to be trauma-informed, because a trauma-informed person is a safer person. And so it does always make me wonder, what is the standard for trauma-informed care? And when I started researching into trauma, I was kind of surprised that there's not so much of a agreed upon definition of what trauma is. And I know we also got into that today, talking about domestic violence. There's not really an agreed upon definition of what that looks like, for good reasons. It's subjective. But as far as trauma-informed care goes, when you're thinking about trying to resist re-traumatizing a family, that's already leaving a trauma, I definitely see the importance of trauma-informed care. And so, I'm thinking about how you get trained as a clinician, sometimes an educator or a medical professional, and you learn about mandated reporting, and it's not even a question that those things you need to listen for, which are going to cause you to have to at least consult, right? So whether it's harm to self, harm to others, child abuse, elder abuse, it's very common knowledge. And I would hope to see us get to that point with trauma-informed care, where we all know the 6 principles of trauma-informed care, or whatever it's going to be language-wise. I just feels like there's a lot of room for growth as far as what is the standard for trauma-informed care? Because like I said, not just our own agency, but for other agencies that are serving these families, if there is a common approach to working with those that have been exposed to trauma, I think that could definitely improve outcomes. The other thing too, since the focus today is on children, is as you guys have already mentioned, not just domestic violence, but trauma in general, it could have a very common response as far as a child's school performance. And so something that I really appreciate here within our program that we do is we're connected to School on Wheels. And I do think I've seen the increase because of COVID, and a lot of students had their withdrawal because of the virtual setup. But on top of that, when they're experiencing DV in the home, there's definitely that drop in school performance. And so School on Wheels is a great program because they're able to follow families. It's essentially designed for homeless families, but there's a huge overlap with domestic violence and homelessness. I know there was a report where a mayor report where it was around 44% of them said that domestic violence was a major cause of homelessness. So there is a huge overlap, and I really like that School on Wheels focuses on that. And again, like I said, they're able to follow families as they rebuild their independence and their stability. And so again, helping the children get re-engaged with school, I've seen it do a lot of good work for our families here in our program, where the children did come in withdrawn and, like I said, not doing too well in school, but they get connected to School on Wheels and they're able to get back into the flow of their academics and make a lot of progress. And so, like I said, I know they service a lot of different counties: San Bernardino County, Los Angeles County, Ventura County. So that's a great, I think, step to try to help families recover. As far as prevention, there's also a really good evidence-based program. So I got trained on it. It's through Futures Without Violence. They're out of San Francisco, which was a great trip to go and get trained. But essentially, they have an evidence-based program called Coaching Boys into Men. So as far as prevention, this is one of those programs where the goal is to utilize the reality that athletes have an influence on their campuses. And so Coaching Boys into Men, you essentially train the coaches on this anti-violence curriculum. And once a week, they talk to their players throughout the season. And like I said, it is evidence-based. And so it has a lot of potential. And when we're talking prevention, one of those or multiple of those players on those teams might be living in a home with DV, but to hear that message coming from someone they look up to, like their coach, it could totally change their direction or their trajectory as far as being a perpetrator themselves. So I actually just got to do a first kind of install of that training for the city of Azusa last week. So I was able to sit with their teen staffers and explain to them what Coaching Boys into Men entails and kind of come up with a plan or how we're going to move forward and roll it out, whether it's through the city of Azusa school districts, or maybe it's just through their community program. But that's another great preventative effort. I also had a really good discussion last week with the councilwoman. She's out of San Bernardino County, and this is to kind of touch on the failure to protect conversation that we've been having today. And I have seen it a lot, where even families that come into our shelter, unfortunately, they'll still have their children removed while the investigation is ongoing. And thankfully, I've seen a lot of children return to their family, but the point is they were separated for those months as they did their investigation. And I've even, unfortunately, seen where the children get sent to abuser. And so when you're talking about the trauma that does to not only the children, but also the parent, the non-offending parent, there's a lot of room for growth. And so this councilwoman, her vision, and I know it's a far off vision as far as how long it'll take to complete, but she envisions a facility specifically designed for those families, where there does need to be that monitoring, but instead of separating the family, they all go into this program. And like I said, we've had clients come into our program where that's what they were told. If you don't go into the shelter, your children will be removed. And so they comply, they come into the shelter, and somehow they still end up having their children removed. So I think having a facility specifically designed for those types of families where there is a little bit more severe of a need to keep them monitored, that would be great. So again, we can decrease the amount of time that we're separating children from that supportive parent. And then something else, that I'm also hoping to see happen here in California is out of Ohio. They are working right now on trying to establish a bill on a state of emergency on childhood trauma. And essentially, it's taking the model of what happened with the opioid epidemic, where it was declared on a state level. And then, of course, back then, President Trump was able to do that on the federal level, which does create a lot more access to just different opportunities to, again, help And I know that's something that's come up today is the psychoeducation around trauma and especially the psychoeducation around domestic violence. So being able to declare a state of emergency on childhood trauma, I think would help, that message really get out there, that it's very pervasive. And again, a lot of the work out of California, I think it is really progressive. I think our first speaker shared that today, that we do have a lot of great work being done. But I think there's also that opportunity there that if we did something like this, then other states would follow suit. And so when you think about, the ACEs study and what we know about childhood adversity and how that shows up on the adult side of life, there's a lot of great motivation and reasons why we would want to do something like this, whether it is just to kind of increase the awareness of the psychoeducation, but also, like I said, to potentially access funds so that we can connect more families to the services that they need. So hopefully, like I said, a lot of these preventative efforts we're able to make progress on, but that's what I have to share today. So thank you guys again for the time. And like I said, it was very refreshing to hear from all the other panelists.
Thank you so much for your testimony. Any questions from our members? Senator Caballero.
Thank you, Madam Chair. I'm not a question. I just want to say that I really appreciate this testimony. This is the hopeful part of it. What I experienced as doing criminal defense work and with domestic violence cases is a lot of times it's really hard to figure out exactly what's going on in the family, what the dynamics are. And there weren't any injuries. It's just pushing, and everybody ended up getting arrested. And and I always recommended that during the time that we could do it, that they be, everybody be diverted and put into a program together so that they could start working out whatever the issues were that they had, because they wanted to be together, and they came in together, they would come in together. And so the whole idea that there are instances where people just need to learn how to communicate better and how to be able to express disappointment. I mean, if there's one place that you're likely to be disappointed, mad, or feeling sad is in a marriage or in a relationship. And if you can learn how to express yourself, that's really important. So these kinds of things, these programs are really give me hope that there's a way to be able to help probably a majority of the individuals that are experiencing this kind of stress, and to be able to learn how to communicate better with themselves and with their children as well. This is hopeful. Thank you for your testimony today.
Thank you for that. Senator Skinner.
Thank you, Chair Rubio, and thank you, Jonathan, for that testimony. What I was struck by is just that how much more we're understanding that both the perpetrator of domestic violence and the victim, their past trauma contributed to their being in the circumstance they're in, to the victims staying in that situation. But of course, there's many other complicated factors. But also the perpetrator, because the perpetrator, it's all power dynamics, and it's like making up for a lack of power they may feel in their own lives. And that our carceral system, whether jail or prisons, is really still not designed to deal with trauma. And so while clearly we have, penal code statutes and such to deal with this, it doesn't necessarily get at the underlying. Now, for some people, I think that it absolutely must be, the incarceration is necessary. However, for many, it may just really be more that trauma-informed care. And in some cases, maybe not together. In other cases, perhaps together, meaning with the two people or whole family. But obviously, the impact on the children is more trauma, and trauma that then can play out later in their lives. So the more we can focus this, where appropriate, on trauma-informed care, the better. And yet we are woefully inadequate in providing resources for such care, and have still primarily relied on the carceral system. So again, any of our panelists, suggestions on how we can do that better, Clearly, budget is one issue, but there's other factors too. We welcome them.
Thank you for your testimony. I just want to point out two things. We will certainly, the members of this panel will explore the state of emergency that you suggested. And it also struck me, I mean, I was a teacher and I know we're mandated reporters, but it's the assumption that we all know what to look for and understand what to report. So I think maybe exploring specific examples and guidelines for those mandated reporters to know and be able to report when needed. Sometimes we see things and perhaps we will not recognize it if we've never been in a situation or come from a home that's never seen violence. So very different. So thank you again. We will now move over to our second panelist. We will hear from Ms. Bobanag. She is with the California Advocates for Child Empowerment and Safety. The floor is yours.
Good afternoon, honorable members, and thank you for this opportunity to present and speak to you in this very important meeting. I am also representing and formerly the founding executive director of the California Partnership to End Domestic Violence, the State Domestic Violence Coalition, and I think I know some of you from that work. I am currently with a 501c4 ACES for Kids, which is something that we had to form of a national coalition of advocates to ensure that child safety is a top priority in family court. But I would like to begin first with the story of Claire Tamponco. On October 22nd, 2000, Claire Tamponco was brutally murdered by her ex-boyfriend, Tari Ramirez. Ramirez stabbed Claire to death in her home in front of her two young children, her 10-year-old son and her 4-year-old daughter. This was one of the worst domestic violence incidents that shook San Francisco Bay Area and the entire state. Why? Because despite over 100 laws in the books on domestic violence prevention, all our systems had failed to protect Claire and her vulnerable children. Like most domestic violence homicides, Claire Tamponco's death was completely predictable and preventable. For more than 18 months, she had repeatedly called San Francisco police to report Ramirez's violence and threats against her. Again and again, she told officers of the escalating violence, her fears for herself and her children, and of her desire that Tari Ramirez be arrested and prosecuted. However, that didn't happen. Claire again called police to her apartment, reporting Ramirez's terrorist threats and telling the dispatcher that Ramirez had a history of violence with her and that she was scared he was going to hurt her. Claire showed the officers the emergency protective order from a September 1st incident, which had not been served. The police filed a quote-unquote terrorist threats report, yet Ramirez was arrested and booked only on public intoxication and providing false identification to police. There was no reference on booking papers to Ramirez's threats or his history of domestic violence. 1 month before Claire's murder, Ramirez appeared in court for a revocation of probation hearing on the October 99 charge of violating his probation by peeping into a public restroom. No mention was made of the previous domestic violence incidents by the DA, according to Judge Lillian Singh. Ramirez, already out on probation, was sentenced to 30 days in Sheriff's Work Alternative Program and ordered to report to the jail on November 1st. However, that on October 22nd, that was the day he brutally stabbed Claire Tamponco over 17 times in front of her two vulnerable children. I share that story because that galvanized the Bay Area community, and also it showed us why, despite some of our laws in the books, things continue to fail us. And we were asked at this second panel to share how we can improve outcomes for children, victims, and families. I think the very first problem, and many have spoken to this already, but I want to highlight it, that child victims of domestic violence, not only as witnesses, but directly injured, are not protected in family courts. National research by Geraldine Staley, PhD, found that over 85% of California mothers who came to court to protect their children lost primary custody to the identified abusive parent. Law enforcement officers, social workers, mediators, custody evaluators, attorneys for the children, and judges minimized domestic violence and child abuse, giving the accused and some convicted fathers unsupervised access to children. That must stop. 73% of California children reported that they were re-injured and some have been killed. These findings replicate other national studies. With California Protective Parents is a national statewide organization, and Center for Judicial Excellence also has a U.S. divorce homicide, child homicides that is on their website. I think the second issue that already been alluded to earlier, but I want to give credence to some of the trainings that have been developed over the years, is that there is a need for standardized and specialized training by domestic violence and child abuse specialists for all court officials, not just for judges. The National Council on Juvenile and Family Court Judges does an amazing conference every year and also provides trainings. Domestic violence experts and advocates all need to work together. So at the state level, if we could have those standardized training conducted by domestic violence and child abuse specialists for all court officials would really help. We will be presenting to you 2 specific legislative proposals, which I won't go into, but just briefly mention. Our first recommendation is because of the issue being victims of domestic violence are endangered and intimidated in family court, victims are coerced into mediating with abusers face-to-face, despite Rule of Court 5.215. Victims are not given time to leave courtrooms before abusers, even when they have a restraining order. Victims are ordered to make custody exchanges without protection, even when they have a restraining order. Our proposed solution is to amend Penal Code Section 264.2 and Family Code Section 3181. That will be submitted to you in writing. But I want to highlight why that's important to our coalition of advocates. First, a party's request for separate sessions is not evidence of his or her lack of cooperation with the process. We will highlight that in the language change that we will propose. Second, if domestic violence is discovered after mediation or evaluation has begun, the parties shall be told separately about safety-related issues and the option of continuing in separate sessions at separate times. This increases safety factors. Third, the confidentiality of each party's times of arrival, departure, and meeting shall be protected. And fourth, any party who requested separate mediation sessions due to domestic violence shall be asked to leave the court 15 minutes before the accused offender if they must appear together in person for a hearing. Our second recommendation will point out to a legislative fix in Evidence Code 730. When families have resources, family courts frequently appoint private custody evaluators under Evidence Code 730. The court rarely pays for the evaluation, even though the appointment is for the court's needs. This addresses what Senator Caballero has said. Not every family enters the court in the same way. Parents are required to pay the unregulated and often costly fees directly to the evaluator. The parent then, with the most resources, may pay more or all of the fees thereby raising concern of immediate possible bias. This does not occur in criminal and juvenile courts. These amendments would ensure that compensation for a private custody evaluation is paid by the court, not the litigants. So we will present to you specific language amending codes, Evidence Code 730 and 731. Additional state level ideas that we'd like to propose is that mediators and evaluators need to do danger assessments for domestic violence victims. Brian, I believe, spoke about this a little bit. How do we scale and really assess the level of danger? And so we need to be able to do those danger assessments for domestic violence victims. Again, domestic violence victims should never have to mediate face-to-face with their abusers or leave the court at the same time. But these dangerous and intimidating outcomes happen frequently in court. All family court hearings need to be recorded by either a court reporter or electronically. More and more, some courts are doing this in different jurisdictions because it requires additional funding from the county or the state. Another idea is any domestic violence victim who is self-represented while the batterer has an attorney should receive a pro bono attorney or have an attorney paid by the other party as required. And then another thing is recent legislation, which was AB 1169 by Assemblywoman Blanca Rubio, requires a form for court-connected professionals to follow the proper protocol for investigating child abuse cases and bring facts and evidence to the court. But more work is needed to ensure the form is properly utilized. Our advocates had tried for over 15 years to get a form to implement Family Code 3118. It took the horrible death of little Piki and his mother, Ana Estevez's advocacy and Assemblywoman Rubio's strong advocacy. But the courts still use Evidence Code 730 to appoint expensive psychologists to do mental health testing when there are allegations of child abuse, especially child sexual abuse. This never turns out well for adult and child victims. Plus, the court makes the parents pay the professional directly, so it only applies when one parent has lots of resources. We are also aware of gender bias against women in courts. Many studies have been done around that. They do this instead of ordering an investigation under Family Code 3118 and using the evidence-based protocol and new form. The deeper issues are the friendly parent laws that lean the court toward shared parenting despite violence. And I think this is where we need to make sure that all those working in the courts, in our legal and law enforcement systems, are really aware of the lethality of the situation so that we can protect both the domestic violence survivor and the child or children. At the local level, I was also asked to present what can be done. Court Watch is an excellent local accountability measure. California Protective Parents has developed a method using college students as court watchers. Again, I will send that to you when we complete this hearing. Multidisciplinary interview centers at the local level, some counties and some nonprofits already have this. Interview centers for interviewing all abused children are crucial. Giving court-appointed special advocates services to children in family court in addition to juvenile court would be a great help. CASA was also mentioned earlier by Senator Caballero, I believe. And many of you are aware of family justice centers with co-located services which would give victims a one-stop shop for services. San Diego has a very nice model, as well as Alameda County. Then, having specialized law enforcement units to investigate domestic violence and child abuse has been shown to be effective, especially if they charge multiple crimes. They need to be the lead agency in all crime investigations. Child welfare services, social workers, should not call the accused before law enforcement interrogation. Another local approach could be domestic violence advocates should be in the courtroom and part of the family court process to ensure victims are supported and the court does not minimize violence. They would be the eyes and ears on behalf of the victims and also would serve that level of training that they have received around domestic violence. And I think this will address the protecting the children even further. If a child 12 or older wishes to file a restraining order against a parent, domestic violence advocates could help in that process. In many of the shelters, which were members of the California State Domestic Violence Coalition back in the day when I served as its founding executive director, the domestic violence advocates at the shelters were so strapped financially often, and they had to only focus on the survivors, the people who have fled their homes. But now things are easing up, and that we need to encourage them to really focus on the children to help them also file a restraining order against a parent. This, again, further addresses Senator Caballero's points earlier. Domestic violence advocates could help children provide their wishes for custody and visitation. And if youth 14 or older wish to testify directly to the court, advocates could help them prepare, ensure they do not have to testify in open court, and ask to be with them as a support person. This is some practice, a best practice that we need to start making sure we implement at the local level.
Ms. Babana, we have about 1 more minute. Thank you.
Okay, I will be ending soon. Domestic violence advocates, welfare social workers need to work closely with each other and with family courts. There has always been a bit of a silo and separation between domestic violence and child welfare organizations. That needs to come together. And the final thing, 2 final points that I want to bring up is the main other solution is on primary prevention. Focusing on preventing first-time perpetration and first-time victimization. California already started this through the Centers of Disease Control called the Delta.
Your audio went off. Do you mind pausing for a second?
Oops, sorry. If we could focus on those, so preventing first-time perpetration, first-time victimization, and reducing risk factors associated with intimate partner violence, and promoting protective factors that reduce the likelihood of intimate partner violence. And then finally, this is already one of the successes of domestic violence organizations is the coordinated community responses, or CCRs, addressing intimate partner violence at the local level. And they must include making child safety a higher priority. The issue of domestic violence and child safety is not just an intersection. To me, it's a co-occurrence because that violence is occurring and then becomes perpetrated over time. And while I would like to also, I work now for a spiritual healing center, is that while our better intervention programs have come a long way, there's much to be done to create, to make sure most perpetrators we know that most perpetrators have been victims themselves as children and have not healed the traumas of their past or overcome the violence learned from their families or communities. And that there is much to be done to create a moral conflict on an individual prior to committing an act of violence. This can only be achieved through a deeper look at one's spiritual and moral compass. Finally, I would like to close and commend the committee for tackling this often neglected and forgotten co-occurrence of child abuse and domestic violence. As policymakers, we have both the privilege and power to institute legislative changes for systems reform to ensure safety for all. California has premier organizations, the Futures Without Violence that was mentioned by Jonathan, Centers for Judicial Excellence, California Protective Parents Association, the California State Domestic Violence Coalition. Those state organizations and advocates must be utilized by the state legislature as your subject matter experts that you can rely on to be able to help change laws, enact new ones, and make sure those laws are properly implemented to ensure safety for both children and women victims. Thank you.
Thank you so much for your testimony and the wonderful recommendations. Senator Skinner, any questions?
The tragedies that you described are beyond comprehension, though we know, unfortunately, they may not even had our various mechanisms worked. It's possible, and we have seen it before, that perpetrators violate restraining orders and such. Though certainly, when we have tools and they are not used, it is wrong. And that women's complaints like this are not taken seriously is something that we know and we have seen repeated and heard, documented repeated circumstances. So we need to do better there. But then you had many other concrete recommendations, which I really appreciate that you're going to be providing to us in writing. So I really appreciate your testimony, and we obviously are committed to working on doing better.
Once again, thank you. And you spoke about a case, Ana Estevez, who lost her little boy, Picky, was 5 years old. She's from my city and a friend. And it was unfortunate that she spoke up so many times and no one would listen. And at the end, she lost her little boy to her abuser because the court failed her. So thank you, and we look forward to those recommendations. If you can email us, we would love to have those. And I need to apologize to the last presenter. We did have technical difficulties at the very beginning, so I'm going to ask that you streamline your testimony as we have another committee hearing after this. So I would like to welcome Mrs. Dudley. Taylor Dudley directs the UCLA Pritzker Center for Strengthening Children and Families. Welcome, and the floor is yours.
Thank you so much, Madam Chair, honorable senators. Thank you for the opportunity to speak today. Last year, we commissioned a study on the connection between domestic violence and child welfare, which I will review shortly. Today, given the time constraints, I'm going to focus on the recommendations and off the top, frame this discussion through an equity lens, as Senator Caballero raised, and highlight how some other states are also addressing this issue. I'd also like to quickly share some slides that will help me stay on track. One moment, please. At UCLA, we acknowledge our presence on the traditional, ancestral, and unceded territory of the Gabrielino Tongva peoples. The UCLA Pritzker Center is a multidisciplinary center at UCLA designed to address and prevent children from entering the foster care system. As this group knows, domestic violence feeds the foster care system to a large extent, and our question has been how to make it stop. For those currently in foster care because of domestic violence, we've asked how families can be reunified and supported with proper services for domestic violence. I'll provide a quick overview of the study that we conducted. Black and Latinx children comprise the foster care system at an alarming and disproportionate rate. The confluence of poverty and racial trauma compound and make this more likely and yet unacceptable. Nevertheless, we see children removed from their homes and placed in foster care for isolated allegations of domestic violence. This can result in further trauma for both the survivor and the children, as has been discussed at length. Our work examines this dilemma and the import of child safety, coupled with the challenges of family separation. Our work was generously funded by the Anthony and Jeannie Pritzker Family Foundation, Van Nuys Charities, and the Blue Shield Foundation of California. We were also pleased to do this work with a number of partners across LA County, including the LA County Domestic Violence Council, DCFS, and many DV and child welfare groups. Our research consisted of over 50 focus groups and individual interviews with survivors, both parents and former foster youth, social workers, lawyers, community leaders, judges, policymakers, and perpetrators. We also conducted a written survey that received over 200 responses. Among these individuals, we spoke with practitioners in other states, including New York, Washington, Nebraska, and Nevada. These conversations informed our legal research and the approaches that other jurisdictions take to address domestic violence and child welfare. As part of the legal research, we also completed a 50-state survey to understand how other jurisdictions address domestic violence in foster care. I'm pleased to share that survey with this honorable committee for its review. For some context, Los Angeles County has the most children in foster care in the country. As of October 2020, over half, 19,000 of the 36,000 children in foster care had been exposed to domestic violence. If this issue that this body is addressing today were meaningfully addressed, imagine the reduction to child welfare-involved families and the healing that could occur instead. Shortly, I will present a number of recommendations to help address this issue. I was going to show a video, but in the interest of time, I'm going to skip it. To better understand the balance of harm between removal and exposure to domestic violence, we did an extensive literature review. We learned that both experiences, removal from the family and domestic violence, constitute what is known as an adverse childhood experience. Exposure to ACEs can cause a strong or toxic stress response and have a lasting negative impact on health, not just during childhood, but well into adulthood. Because of that, we are encouraging this body and the involved agencies to consider the balance of harm when considering removal because of domestic violence. I'd like to start by going over our first recommendation relating to mandatory reporting. Mandatory reporting is something that this audience is familiar with. But what our research revealed is that because of mandatory reporting and systemic racism, an overhaul is required with respect to how we support and serve families. If a family discloses that they are experiencing domestic violence when trying to get help or care, it can lead to DCFS involvement. Even when not seeking help for domestic violence, a family may encounter several mandated reporters throughout their daily lives. Families of color and low-income families in particular encounter mandated reporters at a greater rate and are the subject of more reports than white families or families with socioeconomic means. Racial bias also impacts social workers' investigations and leads to more families of color entering the system. Because survivors may frequently interact with mandated reporters, they may feel pressured to hide the fact that they are experiencing domestic violence. This conundrum is often what impacts those survivors later in their dependency case and is used against them to demonstrate their failure to protect. For this reason, mandatory supporting has been put forward as an alternative to mandatory reporting. Under a mandatory supporting practice, we can call DCFS and hope that it doesn't lead to investigation and provide services instead. A call can also be made, but it just changes what happens after that call by stepping back and asking ourselves, does this family simply need help? It's therefore recommended that this body consider reviewing mandatory reporting laws and how they compound and exacerbate this issue and evaluate the possibilities associated with mandatory supporting. In terms of the second recommendation, training on domestic violence is needed for professionals involved in child welfare to understand the power and control dynamics and the trauma experienced by survivors. The current lack of training can result in decision makers or authority not believing survivors. Not understanding the dynamics of power and control can lead to a decision maker blaming survivors for not leaving a DV situation and an unwillingness or an inability to recognize protective parenting capacity, which a survivor often demonstrates. It's therefore recommended that this body consider training requirements across the entities working with families, including the child welfare system and the courts, with a trauma-informed focus as outlined by Mr. Wicks. In terms of the third recommendation, it follows that training and a better understanding of domestic violence would lend itself to more nuanced service recommendations. To increase the likelihood of reunification and reduce recidivism, a more nuanced approach to services should be developed, and a more targeted and effective domestic violence service should be provided. These services should also be provided to families for free of charge and in a culturally competent manner. Furthermore, while many services are funded pursuant to contracts with various county agencies, we learned after interviewing a number of domestic violence organizations that they were not contractors with the child welfare system despite service delivery to DCFS-involved families. This arrangement should be evaluated to ensure equity among service providers supporting DCFS families and address the often harsh financial realities that so many DV organizations face. It's therefore recommended that this body consider how funding is allocated and directed at these services and assess what degree these services actually help families avoid removal and promote reunification. I'd now like to talk briefly about specialization. Due to the lack of knowledge about domestic violence within child welfare systems, we recommend that the department consider a specialized social worker or a number of them that can actually address domestic violence. Here in Los Angeles County, I'm pleased to share that it appears DCFS is now going to implement this practice under the leadership of Supervisor Kuehl. We are particularly inspired by San Francisco Department of Children, Youth, and Families, which employs a domestic violence specialist in partnership with the Riley Center. In our conversations with a former staff member in this role, we learned that the specialist has the ability to aid social workers in designing safety plans and assign relevant and helpful services. Massachusetts has a similar model in their Department of Children and Families. In Massachusetts, the unit is comprised of a number of social workers, all there to support and address domestic violence cases. With respect to the courts, our second recommendation for specialization is to implement a specialized domestic violence track. This is a practice in Nebraska. There, they have implemented a specialized domestic violence dependency court with a judge, social workers, and lawyers who have experience and extensive training in domestic violence. It's therefore recommended that this body consider the specialization necessary within this field, both within the courts and within the Child Welfare Agency. As Senator Caballero pointed out, guidance for the courts in this area is essential. Lastly, in terms of the statutory change, as I mentioned, we conducted a 50-state survey looking at how every state in the nation is addressing this issue. In Washington, the child abuse statute explicitly states poverty, homelessness, or exposure to domestic violence does not constitute negligent treatment or maltreatment in and of itself. One interviewee from Washington emphasized that despite the statutory text, it can be difficult for a survivor to utilize the statutory provision. However, these are examples of efforts being made in this space that we may like to consider here in California. Additionally, as Mr. Okamoto outlined earlier, case law can be a stronger force of legal protection for families experiencing domestic violence. In New York, there is great precedent under the Nicholson case that recognizes the harm that removal, even brief, can cause and requires a court to balance the harm of removal with the harm of domestic violence in their decision-making. It's therefore recommended that this body consider legislative change necessary to address this issue with both the child welfare and domestic violence communities' ideas and insights in mind. With that, I'm pleased to take any questions that may be helpful to this body. Thank you.
Thank you. Really appreciate your testimony on that, and sorry that we had to rush you, but a lot of important recommendations that were offered, so I appreciate that. And please ensure that we have your PowerPoint presentation so we can share with all members of this committee. And so I want to thank every single panelist that spoke here today, and I do want to give the opportunity to those remote people calling in to testify. So I would like to check in with Senator Skinner if there's any last questions or comment for our panelists before we move on to those calling in.
Just appreciate the comments by Ms. Dudley, and glad that we are going to get that in writing. And then I think I will refrain from, I could say more, but we have public comment and I will have to leave very soon.
Thank you for that. So again, thank you to all the panelists, and we will now move on to anyone wanting to provide public comments. Due to constraints regarding the length of hearings, technology considerations, and cleaning protocols, committee chair may institute limits on testimony, and I will decide that once we know how many callers we have. Now let's begin. I would like to go to room 4203 if there is any witnesses. Seeing none, we will now go to 2040. Anyone wishing to speak? Seeing none. Thank you. We will now be hearing for public comment via the teleconference service. Operator, can you share how many callers we have?
At this time, we do not have any public comment.
Thank you for that. So I will let Senator Skinner wrap up closing comments before we close the committee. Senator Skinner.
Thank you, Chair Rubio. So there's a lot of recommendations made, and we are a big state. And just the, take LA County has been already, some of the data that presented already that we have the largest number of children in foster care from our LA County of anywhere in the whole US, and a good percent of those kids were subject to, were in households with domestic violence. And we know that that's the case in, everywhere else in the state. So the question of how we, and California is very oriented towards county-specific programs in all of these areas. It's our county, our social workers, our county workers, our courts are in effect county courts. And even though we set statewide policy, it's very much up to the counties to deliver. And so, for example, it is completely available to any county to set up the type of program like in Nebraska, where they have a dependency court, where they utilize the social workers and integrate all of the systems and make it very focused on domestic violence. It is available. Not all of our counties take advantage of it. Whether we have to provide some more incentive, or I think those are all things that we have to consider. And obviously we have to think about how we increase the availability of trauma-informed care for both perpetrators and victims, but of course, especially the victims and their children, and make sure that the victims and the children are not punished for being in this circumstance. But I think those are very important, because the carceral aspect alone will not solve this. So I really appreciate all the testimony, and I really look forward to looking at the recommendations in detail with my staff and then collaborating with our chair.
Thank you, Senator Skinner. And I know we've worked so well when it comes to this issue, so I wanted to say thank you for being here, and I'll continue to work with you. I know we heard so many recommendations, when a lot of eye-opening cases that were shared. And I think that the overarching, I would say, theme is education and implementation, and making sure that everyone's on the same page. As Senator Skinner shared, there's a lot of things that counties could already do. It's just figuring out what we can do to support them to ensure that these programs or education happens. But I do want to point out two things. I know one of the presenters discussed maybe separating the victim with the perpetrator or coming at different times. But I want to highlight a bill that I passed this last year, SB 538, which will allow victims now to provide testimony remotely. Unfortunately, the court needed some time to implement, and so it will become a law 2023, and so that will help with the intimidation and victims recanting their stories for fear of being in front of their abusers. So hopefully it's one step closer to making sure that victims feel confident and comfortable, speaking their truth and telling their stories. We also heard some challenges with my bill SB 1141, which addresses coercive control, a lot more work to be done in that space. And again, it's understanding the courts and public safety and others understanding what it is and how we can help enforce it, and whether we have to provide services or funding or anything to help make sure that that it's being utilized correctly. But lastly, I will finish with this. You know, we had some great testimony from all panelists, and what I took away from it is, you know, we do have so many laws that focus on protecting victims, but I was, you know, also really encouraged by what I heard by one of the panelists, and I guess it's trying to bring that balance between leaving a child and a victim in a home where there is abuse, but that balance of what Mr. Okamoto shared, and that is sometimes there's this overreaction that automatically breaks up families when something can be done in terms of providing services and counseling and keeping the family unit together, which may be what's best for that family. So again, trying to bring that balance. I look forward to working with Senator Skinner, Senator Caballero, and all of my other colleagues, whether it's the Assembly and the Senate, to ensure that we continue to push on these issues. Again, I want to thank all the panelists. Your testimony is valuable, and we appreciate the time you took to be here, and anyone listening at home, thank you for listening, but we'll make sure that we have all those recommendations and that all our members here have those recommendations, and we will convene in a future date so we can explore how we move forward with those recommendations. Thank you, everyone, and the committee is now in recess. Thank you.